aspects of international law. Daniel, thank you for joining us.
Thank you, Andrew, and thank you for Elnet, and for inviting me. I thought I'd divide my comments into three with your permission. First, I want to say a few short words about the background to the current round of violence, because one of the things I encounter in many of my interviews, especially in the media, is that people tend either not to remember or to intentionally forget how this round of violence started. So if you were to ask someone in the street, why was there a round of violence between Hamas and Israel a few weeks ago, many people would say it's because Israel did something wrong in Gaza, or Israel is the occupier of Gaza, or something of that nature. And while that has been the excuse of Hamas in the past, I would point out 2 points on that. First, if you actually look at the map of Gaza, you will see that after Israel left Gaza entirely in 2005, Israel is not within Gaza. So you have Israel to the north of Gaza, and you have Egypt to the south of Gaza. And when the Palestinians, the Hamas particularly, keep saying we are occupied, they don't mean that there's anyone in their territory. There's no one in their territory. It means that the neighbors to the north and the neighbors to the south don't like them. And for them, that is a significant excuse to justify trying to kill people, which international law does not allow, but also international logic does not allow. But put that aside for a moment. In the last round of violence, that wasn't even the argument. Hamas actually went public and said the following. They said, there are things going on in Jerusalem between Israelis and Palestinians, and we have a position on that. And if Israel does A, B, and C, we will fire rockets against Israeli civilians in Israel to prove our point. In other words, this is an extortion racket. If you do not accept our political position with respect to a dispute, which is frankly between us and the Palestinian Authority in the West Bank, then we'll try and kill you. And when Israel, I think justifiably disregarded the threat, they started firing hundreds and later thousands of rockets against civilian towns, villages in Israel. So I say that because this is a case of an extortionist threatening to kill you if you don't do something they want. And now Israel is being blamed for hitting back at the extortionists after they tried to kill us, which I think when you put that in context, it makes a lot of the criticism seem rather weird. The second point I wanted to address is the question which you, Andrew, have posed to me, which is what is the process within the IDF to address the concepts that Lori just so eloquently described? And as you mentioned, I spent 20 years of my career as head of international law for the Israeli military, and I was actually personally responsible for setting up these mechanisms. But before I explain what they are, I want to explain that before you launch a military attack, you actually go through a 3-test process. Stage number 1 is the attack has to make sense. In other words, it has to be militarily justifiable. It has to achieve a military objective. You don't fire a weapon system just for the heck of it. It has to have some military advantage associated with it. And that is actually a more strict test than one would think, because you need to verify that the attack that you are contemplating actually makes sense in the scheme of the operation you're looking at right now. It's not just random shooting. And that's got nothing to do with lawyers or anything else. This is an operational test, but it is a very important test. The second test, and I can tell you this test is used more often than one would think. It has to be something which we would view as moral. Now, if you think the legal questions are difficult, obviously the moral questions are even more difficult. How do you define morality in combat? I can tell you that when I was serving in the army, I found a relatively easy test to use. And it's simple. I wouldn't approve something if I couldn't live with myself for having been a part of it. If I couldn't sleep at night after I did that. And it's a test which I cannot quantify, but funnily enough, it's more easy to use than one would think. If it's something that you are unsure if you're going to be happy with yourself afterwards, it's probably not something you want to do. Only after you pass the test of military, it has to make military sense and it has to be moral, you actually hit the legal question. Is it a lawful attack? And to follow on in Laurie's footsteps, there are three questions you have to ask as a military lawyer. One is the target a legitimate target? And a legitimate target is generally a military objective, whether if it's a military individual or a military facility or base, whatever. Secondly, are you using lawful weapon systems? In the case of the IDF, all the weapon systems being used are lawful, so that question does not arise as often. And the third question is the laws of war proportionality question, which Laurie presented earlier. Are the expected civilian casualties excessive in relation to the anticipated military advantage? Now, there's a big question of who has to make all of these determinations in warfare. Because many people have the benefit of hindsight. People who read about wars, study wars, but haven't fought in any of them, don't remember that you have to make these decisions in real time on the basis of the information available to you at that time. So what we did in the IDF, we set up a procedure whereby the authorized military commanders, together with professionally trained, qualified international lawyers, make these determinations together. And the IDF targeting cells include targeting officers, bomb damage assessment experts who can try and give you a picture of what is the expected, what we call collateral damage of the attack, and qualified expert lawyers who will try to apply the principle of proportionality to make sure that it makes sense. And that mechanism, which I put in place about 20 years ago, is running today. There are dozens of lawyers who do that in wartime with the military commanders. IDF lawyers are deployed from the division level and above for these purposes. So General Headquarters, Air Force Headquarters, Special Forces Headquarters, and the relevant division commanders. All of them are given on the ground legal advice with respect to each and every operation and or attack. Now, I want to put this in context. Does anyone think that Hamas has lawyers advising them about the legality of the rocket attacks against Tel Aviv or Ashdod or Ashkelon? I hope not, because otherwise those people are quite negligent in the legal profession. So I know they don't. In fact, they are intentionally targeting civilians. So one of the things which some people call the reverse asymmetry of the situation, most people always refer to the asymmetry of the big Israel versus the small Hamas. In our case, it's the opposite asymmetry. Israel making every single effort to avoid anything which would be a violation of international law, and Hamas making every effort to violate every rule of international law intentionally, willfully, and wantonly. So with this asymmetry in mind, I wanted to move to the third point. And Andrew, I think you, in our pre-conference email exchanges, you said, what will be the consequence of the Israeli army's decision-making process and potentially its after-the-fact investigation process, which I haven't touched upon yet, with respect to the potential ICC investigation. So that will be my third and final point. First of all, the IDF, as most modern serious armies, after every incident in which there is an allegation of something wrong, launches an after-the-fact investigation. In most cases, those will be what we call operational investigations. Commanders will investigate the situation to find out, did something go wrong? And if so, why? In extreme cases, where there is a risk that international law has been violated, if such an event occurred, then the investigation will be transferred to the legal authorities for what we call a legal investigation. So, for example, and this is not relevant to the recent conflict, if there was an allegation of anyone intentionally shooting at a civilian, for example, which is what Hamas was doing, but the IDF never did, then the IDF would launch a military criminal investigation into that allegation to find out if that happened, and if so, who was responsible. Now, I say that because the ICC is based on the principle of complementarity. In other words, ICC is supposed to be a complementary source of jurisdiction, not the primary one. The primary source is still supposed to be national criminal justice. So, because the IDF does investigate allegations of wrongdoing, there is a very powerful argument to be made if and when it becomes relevant that the court should not have jurisdiction over events related to the IDF, because the IDF has a very robust internal investigation mechanism. However, to be fair, that is for the future, because I assume that argument will be raised if and when the prosecutor decides to pursue specific cases. And secondly, it has been made public that the prosecutor sent a letter to the Israeli government with respect to the intention to launch an investigation, and the Israeli government did not avail itself of the opportunity to claim complementarity at that stage, because it did not wish to be seen as collaborating with what it views as unlawful and unjustified legal process. I want to end with two small points. Point number one is, one of the mistakes quite often made by the media is that they assess everything on the basis of publicly available information. I'll give you one example. The famous IDF strike on the tower in Gaza, in which the AP and other international media were stationed. I was asked after that strike, I was interviewed by the Association of Foreign Journalists in Israel. And of course, this was number one on the list. Why did the IDF attack the building where we were stationed in Gaza? And I said I actually talked to the IDF before that, and the IDF had perfectly credible and multiple source verified evidence that that building was being used for highly sensitive purposes by Hamas. It was later published by the IDF themselves that part of those activities were attempts to create anti-Iron Dome blocking mechanisms from Gaza. So let me make it clear. Hamas was trying to develop an electronic capability to prevent Israel from shooting down its rockets so that it could kill more innocent civilian men, women, and children. Okay,
Daniel, you have to conclude.
Okay, so on the basis of that information, the IDF gave a 12-hour advance notice to everyone in that building, including the Hamas people who used it for that purpose, to leave the building. Now, I need to tell you that in warfare, giving 12 hours advance notice to the other side is not recommended practice. It's not legally required either. Israel does that because of exactly what Arya said at the beginning of this session. It does it because of the problem of perception, not because of legality. Because at the end of the day, today, we are fighting two battles in parallel, on the battlefield and in the public opinion. And Israel is sacrificing a lot of its legal military capabilities in order to be able to ensure that it can show everyone what it is doing. But that does not stop people from making determinations on the basis of lack of information because of the personal or political or other bias. I will stop here, Arya, and I will take any questions.
Thank you. I think that at this stage, we don't have any specific question for you, so we will have more